Hello, ma'am. Am I audible? Hello. Hello, can you all hear me?
Yeah, you are audible.
Audible.
Alright. I'm really sorry for all the delay for the technical glitches like whatever happened right now. So, yeah, ma'am, sure. We can start in 2 minutes. We'll all wait.
Yes, Aditi, we can begin.
Yes, ma'am. So, first of all, good evening, everyone. Today we have a very special guest with us. We have Miss Pradnya Talekar. She is an advocate currently practicing at the Aurangabad Bench of Bombay High Court. I mean, I have closely observed her work. I have interned with ma'am, and for those of you who don't know about her, ma'am has graduated as the Bachelor of Civil Law from the University of Oxford, and she's also an alumna from the National Law University, Jodhpur. And ma'am, we're very fortunate to have you with us today, and I'm very happy that you chose to talk to us about this really important topic, which is all about e-courts and e-courts versus global pandemic, and what are the requisite skills that can help us budding lawyers to survive or succeed in that kind of scenario. So, ma'am, as ma'am had told me that she wanted this session to be an interactive one. So, ma'am will pose some questions to us, and she'll start the debate. We will have a very helpful and some of the questions that we have, that the preliminary doubts that we have about the e-court system, is that first of all of us know that there are traditional courts that require attendance of judges, court staff, there's lawyers, and there's parties as well, and there's evidence that can be submitted physically. So how do you do all of that? How does the exact process go on in the practical scenario? And right now we have a temporary relaxation procedure. Now if this whole system becomes a norm, how are we going to go about it? How will the procedure happen? And then recently I was watching this video by Honorable Justice Chandrachud, who talked about the
Yeah, ma'am.
change right now. There's so much happening, so many old paradigms being completely changed and molded into new ones. The willingness of people to, start some stabilize the equilibrium. Eventually, after the first week or so, around 15th of March, there was the order to stop physical functioning, where they decided that courts would sit once a day or twice a day, once or we already had video conferencing in place. Now, once that happened, there were a lot of glitches initially, and even now. So, a couple of funny incidents that happened. Some of clothes. So similar things have been happening across the courts. We had a pronouncement sometime in the first week of April, and I remember my opposing counsel when she heard that the courts and the judges and everybody else could see her. And such things have been happening. And it's funny right now because we are, again, like I said, in the middle of change. It's not to do. Things are going to become very smooth. And one organization that can do a lot about it is the Bar Council, working with the registry, because as Aditi mentioned, Honorable Justice the E-Committee of the Supreme Court of India. And so he had mentioned about how building confidence in all the stakeholders is what would determine the success. The registry, the litigants on board, we are not going to go through with this. And this workshop is, the webinar that we are having on this theme is to add a little bit of could be quick and wrong to judge it in certain ways. So that's how video conferencing happened. Now, what are some of the negative points happening today? One is that the media how the court proceedings would be kind of delivered to the larger public. Other thing is because the system is not so integrated, will change when courts can bring up more integrated devices. Board displays are not functioning, so when we go log on to a platform, going on. So once the display boards come into action, that would change a lot than it is right now. Another problem is that there are several there is not much habit of using it. Nobody knows how to do it. And because bailiffs are not functioning right now, physical notices serving or summons serving is becoming difficult. So will go away. What we see favorably happening right now is because of all of these judges, the completely formal setup and the differentiation between to, or our audio is not working, or the video is not working, the courts will be very kind in saying, call that lawyer up and, put on the speaker for everybody to hear. Happening because we are all united and we're all wanting to deal with this step by step and successfully for all stakeholders, so that corona or the lockdown does not now, like the question that Aditi mentioned, how is evidence being taken, or all the procedures which may require physical presence, how can that be constitutional courts, that is your high courts and the Supreme Court of India, is only a court of law where facts do not need to be newly assessed. You would see the facts that are presented. That question is not that relevant so far as these two courts are concerned. But yes, there was a recent news after the petition filed in the Delhi High Court saying that and I was proud of it, that about 14,000 and some number of cases were being dealt with by the district court since the issuance of orders of lockdown by the central government. Three times that number. And I'm pretty sure that is a similar case in most other parts of the country. Now, how are the district courts dealing with this? There are different types of cases, not all. Where I'm forgetting the name of this self-assumed saint, the Chandigarh case, which came up again, rape allegations against this person who called himself the Guru. His matter. And in that matter, evidence was taken electronically. So certainly there are ways, and depending on what kind of evidence you want to give, if there is a testimony, it can well be taken online, and it is much better in wrongly taken down by the magistrate, because the way evidences are given is, say, I am the witness, I would say something, and then that would be paraphrased and put down by the magistrate that so and so has said this. So is always a great thing, as is done in most arbitrations today. So that's about the question. Now, moving on, unless somebody has any other questions about the content we discussed till now. Anybody? So next, I would like to deal with what are the opportunities that this brings up for all of us, majorly the people connected with courts, the litigants and the lawyers. One very important thing is access to justice. Courts, you would know that very few cases can reach the High Court or the Supreme Court level, those who have the money for it. Most cases would end at the lower court levels because people do not. It's miles away from their village. It would mean going away from the agricultural setup for a couple of days. It would mean doing away with the things that you rely on for your sustainability for those few days, which is not possible. Of the faith that going to another lawyer that I do not know at all, who's a stranger, would fight my case with the equal amount of zeal as somebody that I trust and know in my own village or town, etc. So there are several issues like the higher courts, which is why we see more commercial litigation than agricultural or land disputes in the higher courts. Now, this can significantly change reality for the country. Imagine a case where I come from a remote village in, say, Vidarbha, and I don't have to go all the way till Nagpur, sometimes when I wouldn't even have the to a certain place and then go not only once for signing the affidavit, but go for each hearing, or miss all the hearings and rely on a third party saying this is what happened in your case. So I can now imagine that I can have a lawyer in this remote village. He could just log in and send in my papers. Things have become really easy because you do not need a very good quality scanner to scan your documents. You can just use your phone and some I do not know anybody, not even the domestic help, who doesn't have a smartphone. So in times like today, when the infrastructure has already been set up, this is not so much a hindrance. Doors and frontiers for access to justice, like Honorable Justice Chandrachud very rightly mentioned. And there could be some cases where, the advocate is absolutely unaware of how to use the technology, and in which case there will be to help you file the matters, to help you set up an audio-visual conferencing for the matters. And it is the systemic efforts which would ensure that it is inclusive. The second important thing is time saving. Each of you who has interned would know, I, for one, when I joined litigation, I had realized that 10:30 to 5 is a time that you 10 cases, it's a great possibility that you're sitting in court all day, but none of those 10 cases come up. And there could also be days when there's only one case that starts in the morning and goes on for the entirety of the day. So it is a big gamble. Sentencing could mean you're having client discussions and you open up the platform where the matter is going to be heard, and you keep looking at the board display once in a while and keep doing something else on the side, which means in court. Somebody, for some issues, we can never do away with the physical courts completely. We would still need to have them, but we may not need to have them as the primary source of dispute resolution. You could always bring in more logistic liberty to engaging the best minds in specific specialized areas. So just yesterday, the Arnab Goswami bail hearing was being undertaken. Salve, Mr. Sibal, arguing for almost 4 or 5 hours, which if Mr. Goswami had to engage them and bring them to Bombay, may not have been as easy, because they would have to give up on all their cases in Delhi, may have to schedule a day or two in Bombay. So logistic difficulties for people flying from one city to another would be done away with. Gender disparity. Now, this is something that's very close to my heart. I had heard from all my seniors and some lawyers also that the best place to intern if you want to go into litigation, the first internship should be in the lower courts. And even if you can take out maybe 6 months or a year, you should always work at the lower courts, build your foundations, and then move on to the high court. I understand why they said it. But having had a couple of looks at the lower court, I knew I couldn't stay there for more than one reason. there can be many sexist remarks, there could be many uncomfortable glares, and even in the High Court, I've seen that mentioning could be a very uncomfortable affair for lady lawyers. Now, because of virtual hearings, all of this could go away. You are in the most comfortable and safe, protected environment. And this is not only for lady lawyers, even for most law school students who pass out of good law schools, want to join the High Court or the Supreme Court, not looking at the lower court. One of the reasons is you don't understand that language, you do not know how you'd be treated, it's far off, and even if your main court is the High Court, you would not take a single brief in the lower courts. Now, those differences could be slowly and steadily erased to some extent at least. You would get an easy access to those courts. And even if Marathi is a language that can be used or vernaculars in other states, nobody opposes English. So you could always come down to lower courts and help the foundations, because that is where justice delivery really happens. What else? How many of you have heard about the Swapnil Tripathi judgment of the Supreme Court? Just a show of hand, or maybe yes, no in the chat box. Do we have a very bored audience today? Okay, no. So you've not heard of the judgment, or you're not bored? Okay, no clue. Anyways, so the judgment came up in 2017, and 3 judges bench said, I think Justice Khanvilkar was heading the 3-judge bench, and they said that we must have transmission of all court hearings live for everybody else in the world to see. And which is a brilliant idea. The UK Supreme Court does it. The Australian Federal Court is en route to do it. Some courts in the US already do it. And I have worked on this idea on a bill with some of the members of the parliament earlier. And this is again something which I believe is going to be a change maker in how the judiciary has served the country till now and how it would in times to come. Though lawyers feel always and know that judiciary has been a very strong pillar of democracy, has always come as the beacon of hope and light when something wrong is happening. The recent times could be slightly muddled, but in general, the vision that we have about the judiciary is that they have been strong and independent in all through these years. However, the common man feels largely detached with judiciary. It's an institution that he fears. It is an institution that he may respect, but it is not an institution that he feels he is very closely a part of, or he doesn't look at this institution providing a service to him. This was another of the issues that was covered by Honorable Justice Chandrachud, and I would highly recommend the video is available on YouTube for each one of you to hear it. It's so informative, and it's a different version and perspective, and it's great that the judges could hold such forward-thinking opinions. So he looks at Mr. Suskind's remarks. Suskind has written a book on how technology and courts could no longer be apart. And unless they work together, the courts are going to disappear into nothingness. So the remark that he has, the observation that he has is that slowly and steadily we need to move from looking at judiciary as a sovereign function to a service, and to look at litigants as consumers or customers who require a certain quality of service. And that changes everything as to how we look at justice delivery mechanism. When we say that more litigants need to be informed, the Swapnil Tripathi judgment says that every hearing that is being undertaken, it would be transmitted on the internet live. So the judges are accountable. The lawyers are also within their term. The clients have more faith knowing what is happening in the courts. And this was said not only for the Supreme Court of India, but for courts at all tiers, also the tribunals and the quasi-judicial authorities, which is so important today because there are so many times. I remember a colleague in the office telling me that in one of the matters where that colleague was appearing before the minister, honorable minister, in one of the matters where he was the quasi-judicial authority under the MLRC code. And the people who were briefing the minister from the government itself said that, maybe the divisional commissioner has accepted a bribe and given this wrong decision. And all of this is happening in between the hearing without having any qualms that the advocates from both sides are present, the parties are present. And then the minister goes on, he closes the matter reserves it for judgment, and he goes on to uphold the very judgment of the divisional commissioner, which was informed to him by a subordinate officer to be issued after taking a bribe. So things like this, at least to some extent, can be reduced, can be checked if there is online streaming of hearings. Another thing that this does is, it gets the general public and the civil society involved. So many times, what appears in the newspapers or the way judgments are quoted and misquoted could create an uproar for no good reason. And if people have access to the entire sequence of things that is happening before the courts, because it's not so much black and white, it's easy to blame a judge or a lawyer, but it's never black and white. It's very, very complicated and many layers involved. So when a person from the general public can hear the whole proceeding, he would get the nuances and the bigger picture idea of why a certain case is dealt with in a certain manner. So that, for me, is a great change that can happen. Another issue is of caste disparity or economic disparity, both of which play some role in the courts even today. One would imagine that the advocates, being a part of the intelligentsia, should not be affected by any of this. But sadly, it doesn't play the primary role, but a role. And that in itself, I think, is a terrible thing. And if video conferencing hearings become the reality and the norm, then you decide whether you put in your first name or your second name, or you just say advocate for matter number so and so, and nobody needs to know your caste. Disparities based on caste need not come up as much as they do. Economic disparities may not affect the kind of watch you wear, the kind of shoes you wear, the car you come in. All of this could fall in the background. Merit will certainly get the highest place in the order, because if there are different advocates from different courts appearing before judges every day, you can't keep a tab of which one's face you like better, or somebody having a face value. So it's only what you hear, the substance of the argument, which will rise up in the case. More visibility for junior lawyers. Now, this was again something that I heard Mr. Chandrachud talk about the other day. And he said that a junior lawyer came up to him after a video conferencing hearing and he said, "Sir, I think this is great because now you know my name. It flashed on the screen before you. Otherwise, I would just be XYZ appearing, holding for my senior." So it brings more visibility to junior lawyers. It brings you on a plane which is much more equal, because now the earlier threshold is broken. It's not only changed in some ways, it is entirely transformed. And in that transformation, you or a person with 10 years experience or a person with maybe 50 years experience, we're all on the same plane. And you all have to work effectively towards a new system and, building your credibility in this new system. Of course, people with a very big name, somebody like maybe, Mr. Sibal or somebody else, doesn't need to worry, their name stays. But the biases that can creep in, because judges are humans, to every Tom, Dick and Harry and everybody having their set of people, that may largely reduce. And a nobody can have a name and a label and a standing as much as the other person in the courtroom. What else? Opportunities to appear in different fora. Now, if I was limited to appearing before the High Court, I have a very small world vision. Now, I have the opportunity to appear before, say, the tribunals, before the High Court of Kerala, the Supreme Court of India, different courts. My vision and my understanding of the society, the way it works, my roots become stronger. And those always help me in assisting the court in another matter that I might have. So, a lawyer, they say, is very little of law and much more of a social understanding how the world works. Because law can never be interpreted in vacuum. What you need to know better is the worldview, the bigger picture, how the society works, functions, is governed, etc. So you have many more opportunities with appearing before different forums. Also, it brings a new paradigm in terms of data-based analysis. Data-based analysis for you to decide what kind of area of law you need to work in. Data-based analysis for the institution to decide what kind of cases should I put before what kind of judge, or what kind of cases should I group together. So today what happens is, different judges, the way roster or the sitting list is formed, the master of the roster is the Chief Justice of any court. He decides that if I have 20 judges at, say, Aurangabad, 50 at Bombay, 20 at Nagpur, which judge sitting with which another judge or sitting singly will decide what kind of matters. And this changes every 2 to 3 months. And so he would say the senior most judge sitting with person X would hear all the public interest litigations. Another judge would hear all the land disputes, etc., etc., etc. And then these judges would get matters allotted to them either by circulation for early dates by the lawyers, or by a system-generated date, which is generated by the CSIC or something. So someday a particular case would come up, and a similar case with very similar facts, with very similar issues involved, would come up after 20 days. If they both came up on the same date at the same time, then the judge would save a lot of court time in hearing that matter. And both cases could have assistance from the other judges to help and assist in deciding the case better. So all of these things have more opportunities once you have data feeding for what kind of case is there in the court. So Manupatra has started something interesting. They have started doing readings for judges. So all judges in the high courts are being catalogued based on what kind of decisions did they give. So they see all the matters that were finally decided by Judge A, and they say that out of 100 matters decided by him in the year 2020, he has allowed 50, he has dismissed 50. Out of the ones that he has allowed, so many matters on environmental law, so many matters on some other kind of law, etc., etc. So if I am a person from Delhi, I've never worked in Aurangabad, I want to know whether Judge X is positive when he looks at tender matters, or is he more environment friendly? What kind of a mindset does he have? I just click on it, I get the analysis, and I know where I stand. So I know what kind of arguments should I bring in the beginning, what kind of issues should I focus on, what kind of issues do I leave in the background, what kind of judgments do I need to come prepared with. So all of these strategic decision making in litigations now become much more data oriented. Earlier on also, advocates always did this. So if you ask me that if you're a client and you say whether you want to take my matter before so-and-so judge, I would go back to my experience and think, okay, I know this judge, how is this for bail matters? And then I'd either say yes or no, depending on my personal experience. But now with data available for integrated information, what happens is it's not personal bias, because I could come from a sphere of experienced, catalogued into certain conclusions, or I could come from a sphere of just personal prejudice or bias, because he said something to me in a certain matter, or he didn't allow a particular matter for me. With generalized data from all the cases that the judges heard, I get a little more accurate. I wouldn't say exactly accurate, because that you could never know. But you have some indication of what kind of a judge you're going to be up against and the strategies for preparing yourself in a particular matter. Now, similar data can also be used by the institutions to give particular kind of cases to particular judges, so that the efficiency in dealing with the matters and hearing and deciding the matters quickly is enhanced. Other couple of opportunities or positive things of video conferencing hearings are it adds to climate change efforts, because the more travel includes high amount of carbon footprinting. You reduce travel, especially air travel, you have some benefits of climate change. You save taxpayers' money, which essentially in judiciary is used for better infrastructure, and mostly it is financial and physical infrastructure. The same money need not be saved for the government, but it could be diverted to getting more judges, having more trainings for judges. So these are all the opportunities that I feel that video conferencing hearings pose for the current world if they're made into a sustainable way of dispute resolution. What are the challenges? Access to justice, as it is a pro, it can also become a con depending on how the institution takes or does not take efforts to change the situation. So technology can be empowering. It can also be a divide. If I have the technology and you don't, that's just stupid. I would be preferred not for my merit, but because I have access to that technology. So that this doesn't happen, like I mentioned earlier, the courts and the institutions have decided that they would be the people who support by giving physical kiosks, by having people who are trained to help lawyers do physical filing if they do not have access themselves to technology or procedures of e-filing. Similarly, for even today, when we have video conferencing hearings, the courts are not completely shut. The courts will function. The advocate has a choice of either going before the physical court or operating from your home office or from your office. The judges do not sit in the courts, they will sit in their chambers. So even if you go to court, there's just a device where you can, it's already logged in, and if there's any problem in terms of functionality, there would be people and officers of the court who would help you to arrange the whole thing. So the institution plays a great role in ensuring that the challenges are countered. Similarly, the Bar Council, the registry, the judiciary, the lawyers need to be all taken into confidence. So there need to be leaders from the bar and the bench who would sit together, work out mechanisms, have training sessions, have doubt clearing sessions. Because so many times, initially for the first 2-3 online hearings, we had this, especially for Aurangabad. This didn't happen as much at the Supreme Court or the Bombay High Court because the bench clerks were very, very well trained over there. But in Aurangabad, we saw that so many times the lawyers would keep their mics on, their videos on from the very beginning. It would not only lead to disruptions for the entire hearing, but it would also let everybody else who was on the platform know what they were talking. And sometimes they would be talking to their clients and taking instructions which they would not want the other side to know. And all of that was public. So sometimes we could hear people complain about somebody, sometimes the judge said that, we can hear you. So all of these incidents have happened because there is lack of awareness on how to use a new technology. So this could be bridged by the Bar Council and the registry working together, along with maybe technical experts, because there could be real issues that people are facing. So Webex also has this thing called screen sharing, and Webex is used by the Bombay High Courts. So a lot of times people would just directly, without asking the permission of the court, etc., they would just directly start sharing their screen if they wanted to give a certain document to the court. And the way courts function smoothly in the physical setting is when the master is the judge. He decides whether something happens or not. So there is smooth functioning and 2-3 people are not doing different things at the same time and it becoming a chaotic procedure. But when people start screen sharing at the point they decide it's necessary, it becomes difficult. So then that feature was disabled. There were protocol that came about. But all these things needed problems and then solutions to problems. So if there are issues that people face, technical experts being on board and having this maybe every 10 days, every 7 days could definitely help in solving a lot of issues about the challenges. Another problem is privacy and security issues. Now, not much has been focused on in terms of court documents, privacy and security till now, but we would surely need regulations on this, how to preserve documents, how long to preserve them for, what kind of space would you need? Today, it may not be much, but we need to think of 10 years, 20 years ahead. Do we use cloud computing for this? How do we have privacy settings which are not very overbearing for the lawyers? Would it be possible to put up all the petitions with its exhibits and the replies, everything online, so that a person maybe from another city or maybe another country could access a particular case with all its documents? Because when you read the judgment, it's only the last piece. Unless you've read the entire file with the memorial, the exhibits, the replies, the rejoinders, the short affidavits, you would not, in the complete sense, understand or be able to analyze a judgment in its entirety. There would be some things which are left, which only the lawyers appearing in the matter and the judge would know. And the judgment would never give you the complete 100% picture. So if you have the petitions online, it would change a lot. But what security issues or privacy issues it could spring up? There was a question that somebody raised, my right to be forgotten. Now, these are immensely complicated questions. One doesn't even know whether it could stand the test of judicial scrutiny. But this is a deliberation. These are questions that need two parties involved. And that's what the customers or the clients, and across fields, this is not only about law, not only about litigation, across fields. Unless you have adaptability and learnability, we are not going to make great success stories going forward. Specific to litigation, draftings and pleadings would get a lot of importance now. Earlier, you needed a senior or a known face only to do the time in court. And you would need him to convince the judge of a certain difficult point. But now, because video conferencing mean that long, lengthy arguments may not be as effective as physical courts, it's best that you give a very, very well-drafted pleading. And that could be read by the judge beforehand, and you anticipate all the questions that you're going to get on it. Be prepared, because again, you're right there. It's already difficult because it's not difficult in itself. It's difficult to convey your point or be as persuasive as in a physical setting as compared to a virtual setting, because you are not used to it as much. It's not the fault of the system. It's just what you have adapted yourself to in a physical setting. Simple things like where the gaze of the judge would fall, whether he's talking to the other judge in a certain tone, where is his head tilted, which becomes difficult to see in many, many platforms as on the technology today. It could surely be amended very easily in times to come. But as on today, that's kind of a hitch in lengthy arguments which involve complicated questions. But drafting would certainly hold a more important place. Similarly, like I mentioned, forward thinking, imagining all the questions possible, being prepared with them, because you don't want to miss that time. This is always important, even in physical courtrooms, but gains all the more importance because miscommunication or not being able to clearly reach to the judge is already a possibility. You don't want to add to it by being unprepared or less prepared in any manner. What you would also require is very good listening skills. You would need to be able to understand, because body language now, at least as on today, is not that easily picked up in most platforms. So your listening skills as to who is saying what, and then come out with the on-point answer without going around the bush. Another important thing is for the judges and the bench clerks or the associates to play. It's important for the judges to make sure that if there are 5 people appearing for 5 different parties in a particular matter, that each one of them has had their say. It could be possible that one of them really wants to say something, is trying to say something, but the mic isn't working, so the case just gets decided without hearing that party. And on record, you would have put her name or his name because that person was present, so to say. So this duty lies upon the people who are, like right now in this conversation that we're having, there's a host, there is a co-host, and they're looking at things. If somebody wants to talk, the mic is off, they would be the people helping out. Similarly, we need an administrative body which will be working out this. because the bench clerks are already busy handing over each file, writing down the dates. They have their own functions. We could perhaps need a separate personnel to oversee and ensure that everybody's basic, the mic, the video, any documents that you need to pass on, all of this is working. So these cover most of the new skills that would be required. Now, what is in this for you guys? How could you benefit? How could you think differently? Anybody has any ideas after listening to the whole thing? Okay, there's a question here before I move on to the next one. Could you share your thoughts on access to justice in places like Jammu and Kashmir and Northeast? Great. This was a question personally that I had, a question that somebody also raised before Honorable Justice Chandrachud. Significantly difficult to answer. Because Northeast, not as much, because you don't have as many restrictions on the internet as Jammu and Kashmir, where the government would just decide to pull the plug any moment. So Jammu and Kashmir, surely these are difficult questions, but it would mean that you, when you become a lawyer, you could kind of appear in those matters, and even if they don't have local counsel who could do it, they could easily bring in more efficient, brilliant minds from outside the state to help them solve their issues. The courts certainly have all the power to ensure that limited internet or limited technological equipments to the lawyers specifically may be provided. So these are things that can be worked out depending on how good a leadership you have in the court, in the bar. Northeast, I would say the infrastructure is missing certainly, but as I have heard from some reports of the committee, that the basic infrastructure for video conferencing is already present in the High Court at Guwahati. I'm not so sure about the district courts. But again, this is something that, anyway, the physical infrastructure is also missing, the technological is also going to be missing. So the answer to the problem is not in standing against or for technology, but in really standing up for these regions in isolation and saying that you need to pump in more funds here, you need to have more sensitive policies in these areas. I hope that answers your question. So where we were before is what it means for law students and what video conferencing or virtual courts could mean for each one of you. Do you think it brings some new opportunities or some problems or some new perspectives for you as law students? Okay, great. So anybody who'd like to take on this question, what do you think? How could it... I see the first name I see is Aditya Havaldar. Would you like to take that for me, Aditya?
I would like to raise a point over here. Since we are talking about, since we are talking about e-courts, we would also have the need to train advocates in using video conferencing technology. Now, considering that majority of the advocates who are passing out of law colleges, they are from local law colleges and they may not be as technologically well off or that exposed to as compared to the graduates from better law colleges. So should the Bar Council introduce some curriculum changes, wherein, for example, in Bar Council curriculum, which we have for LLB, we have 4 practical training subjects. So along those lines, could a practical training subject in digital technology be introduced to facilitate advocates to, getting used to the e-court system? Could something of that sort be done?
Most certainly, and that's a brilliant idea. But the first part of your question where you said, that graduates from better law schools would have a better hold on technology as compared to the local law schools, I would disagree for the reason that I held a certain mindset like you earlier on. In about 2011-12, I happened to go to my native village to help out a school. And I was having a conversation with these 4th, 5th graders at that time. And I was trying to tell them about research and how whatever that you want, if you want to know the career options, you go to Google, you type this. And they looked very disinterested, didn't know about Google. So I had to show them, okay, this is how you go to Google. And that time, smartphones were there, not as prevalent as today, but they were certainly there in the village as well. And then I asked them, so how many of you do have Gmail? And this, not many, one or two. And then somebody just said, we have Facebook though. So I asked, how many people use Facebook? And all the hands shot up. And these were really young kids. And this was a village, a remote village. So people do have access. And even if it is a local law school, they may not have the great language, but they have access to technology. They may not know how to use it, which takes a very little, like I've never used Webex till I started appearing in court hearings, but it doesn't take too much time to get to know a new platform. If you know Facebook, you can know Google, you can know YouTube, you can know any other platform because you are used to the basic concept of how to have a user interface with technology. But yes, a curriculum change would surely be the need of the hour, not only for bridging the gap, but even helping graduates from great law schools. Nobody is equipped directly with these things. I think nobody is equipped even for being a skilled advocate in court. There are so many gaps in terms of advocacy training is not there. Though we have a course on PDC, not much happens in the drafting trainings, etc. So certainly a curriculum change in terms of what are the relevant things, the skills required. And one of the module in this could be technology equipments and how to better address court basics. Basics would not take more than an hour or two to explain. That's how you go in, you switch off your camera. Protocols is easy to explain. But developing a skill, now how do you argue using a virtual platform? How do you feel that the judge is still listening to you, he's still with you on this issue when you don't get those cues as you would in a physical courtroom? So these are skills that would build with time and with experience. So you could have modules for this. Great. Anybody else? So my question was, would it have some opportunities for all of you as law students? Anybody has any ideas in this? I think there is a message. At least e-courts should be implemented for the petty cases to dispose them and for speedier justice. So Sanket, in fact, I was also unaware about this till recently, but apparently a part of the e-courts project is also to look at traffic violations, regulation violations. And now I'm not sure if you've been to Delhi recently, but about 4 or 5 months earlier, I was on a case at the Supreme Court and I had to visit the capital. And I realized that the taxi driver just got so alarmed after missing the red light. And he kept saying, Abhi to meri parchi kat jayegi, and now this is the worst thing to happen in the universe. And I didn't have the context. And I was like, so big deal. You'll pay 100 rupees and we'll move ahead. And he said, no. This happened to me the last week and I've already paid a 5,000. It's no more 100 rupees. It's a 5,000 rupee penalty. And this is the second time. And now they will take away my license. And I was like, but you could just, like you always do, why wouldn't you pay off the traffic signal guy? And he said, no, it's not possible anymore because they come with video cameras. And every traffic police is supposed to have a small device over here which has like a video camera. And whenever you stop the car, it would record the car number, the person, the photo, etc. And the next step of e-courts, as I heard Justice Chandrachud on the lecture the other day, was to make this without judges. So you could just put in, they would send you that, so-and-so is your penalty. Would you like to pay it? If you pay it, there is no case. If you do not pay it and if you want to challenge it in some manner, then you go to court. So slowly and steadily, yes, not only are the petty cases going to be disposed, but you could have a judgeless court for things which are really petty and easy to deal with without much need for complicated evidence. But having said that, the question that I asked earlier still remains, which is, what does this mean for you guys? How many of you, is there anybody who's interested in litigation? Nobody? Okay, somebody said, I do not think it will have much of an impact on young lawyers because in the initial years, we need to get sufficient experience on the actual working of courts. although technology will give an upper hand in procedural things, but not in advocacy skills. Snehal, I'd like to disagree a little here because your opportunity to, what you say is right in terms of you may not get the chance to physically look at senior lawyers presenting their cases. But imagine you can be at your home or the college dorm or wherever, and you could see Mr. Navroz Sirvai appearing at the Bombay High Court. You could see Mr. Salvi appearing at the Delhi High Court just at the click of a link, and you could start learning from law school, not wait till you get enrolled in the bar. So learning from advocates. So like we say, appearing on virtual courts is going to be difficult. Similarly, learning from virtual courts is going to be difficult because we are not used to it. But it's not going to be impossible. Rather, I think it's going to give you many, many more opportunities. And not only in procedure. Procedure is a very, very minor thing. In terms of advocacy, now, I'm not sure. Snehal, would you come on the mic? Can we have a one-on-one conversation about this? What place are you from?
Ma'am, I'm currently in Chandrapur. I don't have a very good internet connection. It goes on.
No problem. You're quite audible. So imagine that you're in Chandrapur. You want to practice at the Nagpur bench of the High Court, but your family has a lot of contacts in Chandrapur. You have personal contacts in Chandrapur, which you feel will easily give you matters in the initial few years. So for training and learning, you take mentorship with somebody in Nagpur or Bombay or Delhi or anywhere else. And you also keep taking your local matters from the local court. That is the possibility that virtual courts is going to give you. Would you think this is empowering, or would you think this is not going to affect you or affect you in the negative way?
Well, as you said that by clicking just on a link, I can access Advocate Sirvai's arguments or any other advocate's arguments. That is true. But then I think personally, for me, it would not be as beneficial as it would have been to actually go in the courtroom and see a one-on-one of a judge and an advocate. So, I mean, it's just my view is obviously on a personal...
That's great. That's great. But I want to understand how this view comes because, many others would have a similar view. So, how do you come to this conclusion that... have you interned in courts before?
Yes, I have. I've
interned...
And
what did you learn from your physical hearings, and what is it that had the biggest impact in terms of your learnings?
So, the first thing is the attitude of the judge. When I interned with two senior advocates, and when they were arguing, I could see that when other people were arguing, they were not as impressed as when the advocate under whom I was arguing. Like I could see that because they were arguing in front of each other, they were disagreeing, they were agreeing, and there was they could see the expressions of each other. So I think that could in a way give me some tips as to how I should proceed, or how the judge responds to certain things, and like that's what I think, but it could be different for other people also.
Right. So, of course, like you said, and I agree that physical things like the physical courtroom gives you a better access to looking at the person in 3D, seeing that, his expressions, every small change in angle, everything matters in the courtroom. But today, the platforms are not very equipped. Like even Webex, if all of you turn on your video, the person speaking will not necessarily become the main image, and it could be something else which is absolutely irrelevant in that hearing of that particular matter. And that happens with us quite often, but that's a glitch that can be taken care of very easily. It's just that courts today feel that this is a reactionary measure. So this is being done only to save the day today. It will not be done for a sustainable purpose. But the day they realize that this will have to be done for a sustainable purpose, they will get these glitches cleared, and it should not take a very long time. The second kind of perspective on this is that since our generation is very used to video calling, is used to spending hours on Skype and understanding expressions and emotions, etc., without having the physical closeness, it's easier. And this has been my personal experience. When my senior has appeared in matters on virtual court, for him, it was still slightly different. I wouldn't say it was difficult, but it was different. And he was trying to catch hold of understanding how to look at the judge, what to see, what not to see. But for me or colleagues as young as I am, it was natural. It came much more easily. So I believe that there are many more pros as compared to cons. Cons are going to be there. But this is something that, the embracers are going to be the winners. So the quicker you shift from the side of, no, we don't want this, to how can I make best use of it, the first mover advantage will be yours. Anybody else? Yeah. Anybody else in terms of, so Sanket says he wants to do litigation, I think. So Sanket, what do you think virtual courts would mean for new law students who are just entering the bar? Or even students who are not entering the bar, who are just in their third year or fourth year and still in law school. What could it mean for all of you? Sanket, can you hear me? No, I don't think he's there. Can you talk? No. Okay, I'll just put a few points and then maybe you guys can respond. So one is, it's easier to get into the litigators club. Most people don't join litigation because it's difficult to break through. It's difficult to get personal matters. It's difficult to get that first case before the court. You don't know whether you'll make it into a good lawyer or not. There's too much uncertainty. There is financial insecurity, etc., etc. With virtual courts, you can take your time and like most of you know, once you get your sanad, till you pass the bar council, you can just give a undertaking and work on it. So even if you're giving yourself say 6 months or a year, now it is so easy to have mentors from across locations and across jurisdictions. It is so much more easier to have visibility before courts, for the courts to know that you are XYZ and you're capable of a good mentioning, of a good adjournment, of a good substantive argument. So all of that is easier. Plus, you can have your own clients. Many people struggle in deciding where they want to be based out of if they are doing litigation. And like we took the example of Snehal, who stays in Chandrapur, a lot of us don't come from Delhi, Bombay type of cities which have the best litigation opportunities. But what if I can use my contacts in my home and still work out matters with my senior in Delhi or Bombay or some other place? So this is an immense opportunity for people to think when they're joining litigation, they don't need to be confounded on going to a big place or a small place. You can have the best of both worlds today. You can have a much more organized career, because once you have all of the data entry, like to give you an example, there are about 3.25 crore cases pending in all the courts across the country, out of which about 38 lakh cases are about Section 138 Negotiable Instruments Act, that is the check bouncing issue. Now, if this forms such a big portion of the cases, it's a big piece of the pie. So you can decide based on data specific to your district, and all of this is available online even today. If you look at the National Judicial Data Grid, you can go down and see what matters are pending at the Bombay High Court, what matters are pending at maybe the Chandrapur district court, the lower courts in some place, city civil courts. All the data is available in terms of numbers. You may not have the names or the orders, but you have the percentages, which will help you decide whether this is a good opportunity for me to jump into, whether this is an area which is a booming area, whether this is something which is a niche area, and your choices could be different. But data just gives you more opportunities to make informed decisions, which are more likely to be successful decisions. So that is something else that changes for new entrants. And because you have a more equal place and everybody starts from ground zero, it's easier to compete. Like few years before, you could see great young lawyers in competition law. Though the Competition Act came up earlier, but the courts started functioning and the system was in place only after about 2005, 2004. And one of the first persons to write a commentary on that, Mr. Abir Roy,
That became really clear. I really love this point that you talked about it. Basically, means that people have I'm sorry. Your voice is getting cut, so I'm not very sure whether you've ended it or you're still talking. Am I audible now? Yes. Consider, that people have a sense of belongingness to the judiciary and that general public is involved in the justice delivery. I think these were the major takeaways that we could grasp from your whole lecture. And I think all of us will be very fortunate that we could learn from you about the practical process and the challenges that we might face when this procedure becomes known. And then you talked about database analysis that we could build, visibility to junior lawyers and things like that we had no idea about. Ma'am, am I still audible?
In bits and parts.
Yes. Okay. So what I wanted to say is that we're really thankful, we're really grateful to you for this detailed analysis and I mean, as you said, that willingness to change your mind.
Yes, I heard that part. Thank you all of you for being here, and I hope that all of you go with some. Yes, Aditi? Not at all. This is exact. We can have things that happen over the webinars and video conferencings. Bye-bye.